Ladies and gentlemen, on behalf of THAC, I would like to warm welcome you all to the Thai-Chinese International Arbitration and Mediation Center webinar. First of all, may I invite Dr. Prasit Aswawathanaporn, Managing Director of THAC.
This one.
First of all, may I invite Dr. Prasit Aswawathanaporn, Managing Director of THAC, for giving the opening speech. Please welcome.
Thank you. Good afternoon. Mr. Wang Sulin, Chairman of the Hainan International Arbitration Court. Mr. Huang Kai, First Secretary Counselor of the China Embassies. Mr. Su Da-chou, Secretary General of TCIAC. Ladies and gentlemen, on behalf of Thailand Arbitration Center, I would like to welcome all of you to the Thai-Chinese International Arbitration and Mediation Center webinar. The economic growth of China has a positive effect in Asia and global economics, particularly Thailand and Southeast Asian countries. Today, China and Thailand continue to strengthen and improve their bilateral economic and commercial relations. Undoubtedly, the economic expansion brings more international transactions, and inevitably, more international transactions bring international disputes. Alternative dispute resolution, or ADR methods, are the best ways to promote the development of business relationships and to settle international disputes. In Thailand, the leading organization for ADR is the Thailand Arbitration Center, or THAC. Our mission is to promote and to provide services related to alternative dispute resolution, both domestically and internationally. We offer a vast array of ADR services that span from our state-of-the-art venue for hearings and events to the international standard of arbitration and mediation administration. Hainan International Arbitration Court, or IAC, is the only arbitration institute in Hainan province. Since its inception in 1996, HIAC has gained great experience in settling international disputes and is renowned for its high reputation and its influence, not only in China, but also among all ASEAN countries. The growing interest of Chinese and Thai investors and the increasing number of transactions between these countries have inspired Thailand Arbitration Center, THAC, and Hainan International Arbitration, HIAC, and the Thai-Chinese Law Alliance Association, TCLAA, to create a new alternative dispute resolution center in order to become a new hub for promoting ADR, providing excellent services, and a new platform for coordination between Thailand and all Chinese ADR centers. With such vision, on 22nd of June 2020, at the THAC office, the three parties signed the agreement that established the new Thai-Chinese International Arbitration and Mediation Center, or TCIAC. This TCIAC will not only provide services to Chinese-Thai disputes, but also to Chinese or Thai investors whose interests may vest in other countries. The headquarters of TCIAC is located in Bangkok, with the first branch office is located in Hainan, initially under the administration of HIAC. The creation of this new center represents a model of cooperation between arbitral institutions to support investors for the growth and the prosperity of both countries. I would like to take this opportunity to announce that TCIAC is ready to provide its services from now onwards. This webinar represents the first event of TCIAC in Thailand. Our distinguished panelists will discuss in details about how to create an effective ADR mechanisms to resolve Chinese-Thai disputes, as well as the importance of TCIAC. In addition to the discussions, arbitrators, mediators, and counsels from both China and Thailand are attending this event, sharing their experiences and perspectives on Thai-Chinese disputes. I also would like to announce that next year, early of 2021, TCIAC will organize an official opening of our center. We expect that councils, CEOs, and experts from China and Thailand will gather here in Bangkok to celebrate such a great event. I am delighted to invite all of you to participate again in this upcoming event. Last but not least, a special thank goes to Mr. Wang Silin, Chairman of Hainan International Arbitration Center, as well as Mr. Huang Kai, First Secretary Counselor of the China Embassy, and Mr. Su Dato, Secretary General of TCIAC, for their endless efforts in organizing this webinar. I want also thank all the speakers and participants that are participating in this event, and I hope this event will be very productive and fruitful. Thank you so much.
Thank you, Dr. Prasit Aswapathanaphon, for giving such an enlightening opening remark. Next, may I invite Mr. Wang Shilin, Chairman of the Hainan International Arbitration Court. Please welcome.
Oh.
线上来宾们，大家下午好，我是海南国际仲裁院理事长王雪玲，很高兴以线上方式参加本次中泰跨境可选择性争议解决方案研讨会。我也很欣喜地看到泰中国际仲裁与调解中心在经过一段时间筹备后，正式在曼谷设立。在此，我谨代表海南国际仲裁院对中泰国际仲裁与调解中心的成立表示热烈祝贺。泰国是一带一路沿线的重要国家，历史上众多海南下南洋人从事经贸活动。泰国是聚集最多海南侨胞侨眷的国家之一。很多知名的泰国企业家都是海南后裔，有着深厚的群众基础。中泰两国建交45年来，一直保持着良好和密切的经贸往来。自2013年起，中国一直是泰国第一大贸易伙伴、第一大客源国，也是泰国第3大外资来源地。频繁的经贸往来必然会导致纠纷的增加。仲裁和调解作为解决争议的重要组成部分，在化解纠纷、促进国际贸易等方面一直发挥着重要的作用。近年来，中国在持续推进一站式多元解决纠纷机制的建设。习近平总书记指出，要坚持把非诉讼纠纷解决机制挺在前面。为了充分贯彻习总书记的重要指示，为“一带一路”营造良好的法治环境，最高人民法院支持和鼓励中国仲裁机构与“一带一路”建设参与国的仲裁机构建立联合仲裁机制，为非诉讼解决机制提供更多的保障，满足中外客户的要求。海南国际仲裁院海南仲裁委员会作为海南省政府依法设立的唯一一个 民商事仲裁机构，自1996年成立以来，共处理了超过15000件民商事纠纷，争议标的金额达到550多亿元人民币。近3年来，我院受理的案件数量年均在2000件以上。2017年和2018年，争议标的均超过100亿元，是全国10家仲裁机构和10家涉外服务仲裁机构。当前，海南正在中央政府的支持下，全力推进自由贸易港建设。海南国际仲裁院担负着优化自贸港营商环境、建设区域性国际争议解决中心的重要使命。海南与东盟地缘相接，海域相连，人文相通。海南国际仲裁院近几年积极与东盟国家的仲裁机构，比如柬埔寨国际商业仲裁中心、马来西亚亚洲国际仲裁中心等建立合作机制，积累了一定的合作经验。海南国际仲裁院与泰国仲裁中心一直保持着友好的合作交流关系。我们在2019年签署了合作备忘录，对相互推荐仲裁员、互为开庭地点等问题达成了共识。此次我们和泰中法律联盟协会作为共同发起人，在曼谷设立泰中国际仲裁与调解中心，标志着2个仲裁机构的合作升级，这对国际仲裁合作有着十分深远的意义。TCIAC 让中资企业在泰国投资遇到商事纠纷时能有一个新的选择，使得在异国的中资企业家在处理纠纷时多了一份归属感。我认为泰中国际仲裁与调解中心的设立不仅仅是增加了一个争议解决的平台，也是海南国际仲裁院和泰国仲裁中心对建立联合仲裁机制的一个积极的探索。TCIAC 的设立可以让客户选择更适合商事纠纷的仲裁地、开庭地和仲裁员。目前，海南国际仲裁院有247名外籍仲裁员，其中经 THAC 的推荐吸收了15名 THAC 的仲裁员，他们都是泰国杰出的法律工作者，职业范围涉及金融、地产、知识产权、股权交易等多个领域。待 TCIAC 中国办公室挂牌使用后，我相信在多边贸易日趋频繁的背景下， HIAC、THAC 和 TCIAC 能共同为各国跨境投资者提供更加卓越的仲裁和调解服务。本次活动的举办离不开泰国仲裁中心、中国贸促会驻泰国代表处、泰中法律联盟协会在曼谷的精心筹备。希望听完各位线上专家的分享，能对中泰仲裁的现状有一个深入的认识。在此也感谢各大商会对本次活动的关注和支持。欢迎各位泰国的企业家到海南自贸港考察投资，希望在疫情过去后，明年能在曼谷相聚。最后，祝此次线上研讨会圆满成功，谢谢大家。
Thank you, Mr. Wang Shurin, for honor giving welcome speech today. Next, may I invite Mr. Huang Kai, First Secretary Consular of China Embassy. Please welcome.
感谢主持人，尊敬的泰国仲裁中心 Pasit 博士，尊敬的海南国际仲裁院理事长王学林先生，尊敬的泰国国际仲裁与调解中心秘书长史大陀先生，尊敬的泰国 Langsy 大学法律硕士院院主任 Tanis 先生，泰国仲裁中心调解员 Cassie 先生。线上的各位同仁、女士们、先生们，大家好！非常荣幸出席此次由泰国仲裁中心、海南国际仲裁院、中国贸促会驻泰国办事处、泰中法律联盟协会共同举办的中泰跨境可选择性争议解决方案研讨会。首先，我代表中国驻泰国大使馆经商参处，向此次研讨会的主办方表示衷心感谢，并向主讲嘉宾及参与讨论的各位朋友表示热烈欢迎。中泰两国长期保持亲密的政治经贸关系，贸易投资合作持续健康发展。今年1到8月份，虽然世界贸易受新冠疫情冲击而普遍低迷，但中泰双边贸易仍保持良好的发展势头。根据中方的统计，中泰进出口总额达625.77亿美元，逆势增长6.7%，贸易增速在中国主要贸易伙伴中仅次于越南和中国台湾。中国长期保持泰第1大贸易伙伴地位，泰国也是中国第14大贸易伙伴，超过了英国、法国、加拿大等发达国家。同时，中国也是泰国重要的投资来源地。2019年，中国在泰国投资额达86亿美元，首次超过日本。预计未来中泰经贸投资发展势头将持续向好。随着中泰经贸投资关系的快速发展，商业纠纷也不可避免地出现增长，这对两国的跨境商务解决争议提出了更高的要求。如何妥善处理贸易投资纠纷，保护当事人的正当权益，建立与中泰两国经贸关系水准相匹配的争议解决机制，已经成为了政府和业界共同面临的课题。在使馆日常与业界的交流中，许多当事人，特别是中小企业，一方面对国外的政策法规理解不足，缺少核实合作伙伴自身资质的有效手段；另一方面，则认为利用法律手段解决争议费用高、时间长、执行难，从而导致大量的贸易投资纠纷难以解决。因此，如何提升当事人的法律意识和风险观念，如何便利和鼓励当事人利用多种法律手段解决争议，是法律专业人士面临的共同挑战。从这个角度讲，此次研讨会的召开恰如其时。希望各位主讲人和听众畅所欲言，集思广益，为推动完善中泰跨境争议解决机制献言献策。最后，预祝此次研讨会圆满成功，谢谢大家。
Thank you, Mr. Huang Kai, for the honor-giving welcome speech today. Also, I want to thank you, Mr. Li Feng, to be at the present to support us. Mr. Li Feng is the initial representative of the China Council for the Promotion of International Trade. Thank you. And next, it's my pleasure to introduce Ms. Li Xiang. Ms. Li Xiang is qualified in China, specialized in international commercial law and foreign direct investment, with abundant experience advertising clients on the range of cross-border issue, covering a wide range of the areas such as investment and high-profile dispute resolution. To be the moderator today. Please welcome Ms.
Hello, everyone. Nice to see you. I'm Liu Cheng, the moderator for the next following section for the seminar part. Firstly, it is an absolute honor to be here with all of you and welcome all of you to join us online. Now we are moved to the seminar section. In this session, we will have 4 speakers giving their vision and experience on trading dispute resolution between Thailand and China. First of all, if it is appropriate, may I introduce our first speaker to you, Mr. Yato. Mr. Shi is the Secretary General of TCIAC. He is a Chinese lawyer with over 18 years significant experience in legal practice, specializing in international commercial arbitration and dispute resolution. He is regularly stating and chairing in both local and international arbitrations with a wide range of civil and commercial area. He has a great many experience in arbitration. Mr. Shi now is the arbitrator of THAC and Hainan International Arbitration Court. So Mr. Yato today will introduce from his perspective about TCIAC and a prospect of the future. Let's welcome.
Okay. Dear Mr. Kunpase, Chairman of Thailand Arbitration Center, Mr. Wang Xuelin, Chairman of the Hainan International Arbitration Court, dear Mr. Huang Kai, First Secretary Consular of the Business Sector of Chinese Embassy, Mr. Li Feng, Chief Representative of CCPRP Thailand. Ladies and gentlemen, good afternoon. It's my great honor to attend this webinar, and my topic is how to manage the dispute of cross-border investment and the trade between China and Thailand. Just how many minutes? You ready to share? Yeah. Okay, so I have divided my presentation in 3 parts. First, choice of applicable law. The second part is choice of dispute settlement location. The third is choice of dispute settlement institutions. And after that, I will briefly introduce Thai-Chinese International Arbitration at the Mediation Center. So let's go with choice of applicable law. So in practice, when we draft one contract, we need to select which country law shall govern the contract. We have 3 options of choice during the transaction between Thailand and China: Chinese law, Thai law, or any third country law, for example, Singapore law. As long as contract parties agree to select any country law, for example, Thai law, to govern this contract, it will become effective for contract parties. It means contract parties can select any country law to govern the contract. Please be aware, this is only for cross-border business transactions. For example, China is not allowed to select third country law for domestic business transactions. So this is very important. Then when parties select government law, only can select substantive law, does not including procedure law. For example, if the parties agree Chinese court has the jurisdiction over the case and the Thai law is applicable, then the case shall submit to Chinese court, apply Thai civil and commercial code. But the Chinese court shall be in accordance with the Chinese civil procedure law. In this case, the parties at least need 2 lawyers. One is Chinese lawyers who can understand Chinese procedure law, and 1 Thai lawyers who is practicing Thai civil and commercial code. This is a little bit complicated at a higher cost. So it is very, very important for parties to understand the way to select applicable law. Then let's move to second part, choice of a place for dispute settlement. So in practice, depend on different party positions, parties may select China or Thailand or another country as a dispute settlement country. But in practice, I saw many parties select third countries, such as Singapore, as a settlement location. The reason why parties select third country because they need a balance. Chinese is not familiar with Thai, and the Thai is not familiar with Chinese. Then let's go to a third country. In fact, both of them are not familiar with the third country law. The purpose to select third country is just for balance, in my opinion. So I have one case I would like to share with you. Okay, let's go to third. Yes. Alternative dispute resolution institutions. Alternative dispute resolution institute. As far as my understanding, so far we may have two dispute resolution, by court or by arbitration. By court, if you select, go to the court, or you have not make any selection of a dispute resolution. When dispute happened, parties need to submit the dispute to the court. Unfortunately, the court judgment cannot take cross-border enforcement. For example, we cannot take Thai court judgment to China for enforcement. This is a big issue for international business transactions. Another issue is during the court hearing, parties cannot select language to use. For example, in Chinese court, you cannot select Thai language and have to use Chinese language. This is a little bit inconvenience for Thai if they take a hearing in China. And also similar, if Chinese take the court hearing in Thailand, it's a little bit inconvenience as well. So another option for dispute resolution is arbitration. Therefore, if parties wish to use arbitration as their dispute resolution, they need to put this arbitration agreement item in the contract, which if there is any dispute cannot settle, parties has to submit the dispute for arbitrations. The court will not accept the case due to this arbitration agreement. I would like to give one arbitration example, item examples. For example, any dispute arising from or in connection with this contract shall be submitted to Thai Chinese International Arbitration and Mediation Center, TCIAC, for arbitration, which shall be conducted in accordance with the TCIAC's arbitration rules in effect at the time of applying for arbitrations. So this is the example for arbitration item. Then what is the benefit for arbitration then? We said, I summarize the arbitration have 4 points for your reference. First, parties' autonomy. It means the concerned party has freedom to choose its own arbitrators, language used in arbitration, as well as applicable law. It means in Thailand arbitration, for example, in TCIAC, you can select use English or Thai or Chinese during arbitration. From my perspective, most of Chinese cannot understand Thai properly during the court hearing. So we can select use English language for arbitration. This is more convenience for both of the parties. Mostly important is you can select your trusted arbitrators to conduct your case who is professional and expert. Then another thing, second, the benefits of arbitration is when arbitration is final. Once arbitration award is rendered, it will be effective. The concerned party is not allowed to appeal in the case. It will take only a very short time, for example, 6 months, the maximum, to receive arbitration award. TCIAC rules, the arbitrator shall issue arbitration award in 6 months. And three, the benefit is arbitration is confidential. The arbitration proceedings are not carried on publicly so that the concerned parties' trade secret and reputation are protected. The third, the fourth benefit, I conclude like it can be recognized and enforced internationally. China and Thailand are members of the New York Convention, so arbitration award can be enforced in China and Thailand. It is very important for international business transactions. Arbitration award can be enforced at 163 countries, which including China and Thailand. So I would like, So I would like to share one case with you, which is pinpoint for choosing SIAC, Singapore International Arbitration Center. We have one client, the client purchased a Thai company in Thailand, share purchase agreement. And this agreement, they select dispute resolution in Singapore in Singapore International Arbitration Center. When dispute happened and the client noticed that it's very high cost. It's the total dispute around 100 million baht, and the cost, which including lawyer fees, arbitration fees, it's about 20 million baht. So the client thinks very high cost, and the very important is like for the Singapore International Arbitration Center, if they cannot issue preliminary injunction in Thailand in order to protect the interest. So they request DTL office to try to take litigation in Thailand. So because the share purchase agreement have an arbitration agreement, so we have to consider use tort law or criminal law to take litigation in Thailand. This is very hard for us. So this is the case for our to study and to understand when we select the location of a settlement is very important. We need to think lots of things. Okay, then let's move to the part. Please allow me to briefly introduce Thai-Chinese International Arbitration and Mediation Center, TCIAC. So TCIAC was founded by Hainan International Arbitration Court, Thailand's Arbitration Center, THAC, Sino-Thai Law Alliance Association, and the headquarters located in Bangkok, and the first branch will be in Hainan, HIAC. So the purpose of TCIAC is resolving economic and trade disputes between Thai and Chinese enterprise, as well as all those of Chinese and overseas Chinese through mediation and arbitration in an independent and fair manner. We have now we have our own arbitration rules and mediation rules in place, and we also have our own panel list of arbitrators and mediators in place as well. So, so TCIAC arbitration, we saw the pain points of choosing seat of arbitration in the third countries. As I mentioned, when we select the settlement, the location of a settlement, we need to consider the law, language, cost, and the balance very important. So TCIAC, the parties can choose arbitrators from China, Thailand, as well as the third countries. So that means a Chinese client, a Chinese party, they can select the trusted Chinese lawyers or Chinese legal expert as their arbitrators. Then Thai parties also can select same as their trusted arbitrators or mediators as well. Then the chief arbitrators probably gonna select from another countries, for example, UK, for example. So it is the balance. And then TCIAC language, we can select, in the contract, we can use Chinese, we can use English, and I use Thai to conduct the arbitration. And also TCIAC, we understood, the business, the company is, needed to solve this issue as soon as possible. So we can save in the time and the cost. And also very importantly, we can issue preliminary injunction can be ordered, which can take enforcement in Thailand. And also TCIAC will create more job opportunity for Thai and Chinese legal professionals. This is very important because if we select certain countries, for example, go to Singapore, I think what we do, Thai lawyers only can wait until the arbitration award is issued from Singapore and then take enforcement. So if we take the case in TCIAC, then Chinese legal professionals, Thai legal professionals can have more opportunity to perform their duties. Then mediation is one of the most important for cross-border dispute resolution as well. So mediation is one of TCIAC's importance for dispute resolutions. TCIAC's mediator panelists are comprised by distinguished people who have qualifications like social influence or are experts in the certain fields, who are able to increase the opportunity of successful mediations. So our objective of TCIAC is to avoid and resolve economic and trade dispute in an independent and fair manners. So in the future, if you have any contract or any business opportunities, please write down arbitration agreement as follows. For example, any dispute arising from or in connection with this contract shall be submitted to Thai-Chinese International Arbitration and Mediation Center, TCIAC, for arbitrations, which shall be conducted in accordance with the TCIAC's arbitration rules in effect at the end of the time of applying for arbitration. If you put this agreement in your contract, then any dispute happens, the court have no right, and the court will not accept this case. So you can submit to this dispute to TCIAC for what we said, fair and good manner for the dispute resolutions. So I think that's today for my presentations. Thank you so much for your patience. If you have any further inquiry, please contact with me by WeChat or telephone number. I'm very happy to answer. Thank you so much. Thank you, Chang.
Thank you, Mr. Shidato, for this excellent presentation. From your speech, we have learned that it's important to have effective management mechanism in Thai and Chinese investment and trading disputes. And apparently, TCIAC already taken a step forward. So welcome our next speakers, Mr. Tane. Dr. Tane has been actively involved in international law and diplomacy since his study in the United States. He graduated from the George Washington University with 2 master's degrees and doctorate degree both in law. All of the studies related to international law, especially economic interaction between the rich and the poor countries, or the so-called the North and the South, and the concepts, principles, rules of international laws pertaining hereto. Dr. has served as ambassador attached to the Ministry of Foreign Affairs of Thailand. He is now the faculty member of the School of Law of the Ransi University. Today, Dr. Tenne will introduce us managing cross-border for China and Thailand alternative dispute resolutions. Let's welcome him. Thank you.
Okay. I hope you can hear my voice. Okay. The ADR Corporation has already been well in existence and is likely to continue to flourish in the future. This is my assumption. Why do I assume that? I will start with the question, are China and Thailand strategic partner and investment partners? The answer is yes, because China and Thailand have long been strategic partners in terms of trade and investment for a long time ago. In history, the two countries have been in diplomatic relations since 1975. The relation between the two countries has or was born out of crisis management, such as the fight against Vietnamese invasion in Cambodia in 1970s, and the cooperation to solve the East Asian financial crisis in 1997. In both situations, China contributed tremendously to the Southeast Asian region peace, stability, and prosperity. It is interesting to note that one Chinese scholar appeared on the screen, Xu Fangji, if I pronounce it correct, in his article, he points out, he opines that China-Thailand relations are as good as one family. So the relationship between Thailand and China is very, very good. And the second question that I have to ask, or we have to ask upon ourselves, what are the Chinese policy to promote trade and investment in the world, in ASEAN as well as in Thailand? Because this is very important. The Chinese government policy may contribute tremendously to China-Thailand ADR cooperation. In this context, I would like to point out that as China grow economically and prosperous and seems to be the leading countries in economy or to be number one in the very near future, they have several policies: the sea policy, the land policy, the river policy, as well as something else. What I would like to mention here is, first of all, the sea policy. China, in 2013, the Chinese President Xi Jinping proposed the concept of Maritime Sea Road, whose main purpose is to cut sea lanes connecting Southeast Asia, East Asia to Africa. And this is very important to better allocation of resource of the world. However, the main obstacle in making the sea lanes, I can say that maybe the conflict over the Spratly Island in the South China Sea. And this conflict involves not only China, but also Brunei, Malaysia, Philippines, and Vietnam. In this respect or in this context, Thailand may be the country which, in the expectation of China, a more neutral ASEAN member state to play a more mediation roles or conciliation roles. The Maritime Sea Road, sometimes known as the Belt and Road Initiative or BRI, sometimes this is known as One Belt, One Road Initiative. Okay. Now let's turn to the land policy. As I have already stated, the sea lane policy may be difficult at this moment because of the conflict in the South China Sea in the Spratly Island. China has also opted for another policy, and that is the Southwestern Land Corridor. This is the land policy which involves construction of roads from provinces in the southwest region of China, pass through Indochina Peninsula, connecting and end at the arrival state of the Indian Ocean. There is a Chinese saying that no road, no development. However, the main impediment of this policy is that the cost of construction of the transportation on land is very much higher than on the sea. Now, I would like to turn to the river. It is interesting to note that as far as China and Thailand, as well as ASEAN is concerned, there is an international river connecting China and the riparian state in Southeast Asia, and that is China, Cambodia, Laos, Myanmar, Thailand, and Vietnam. The Mekong River can be used as a transportation, and if the policy is successful, we may have another route to trade and to do the investment from the southern part of China and the riparian state of Mekong River. Okay. My third question is that will ADR cooperation between China and Thailand be possible? I mean, arbitration, conciliation, and arbitration. I think the answer is very positive in my view. It will be highly possible since the two countries are amenable to the ADR and have similar policy in this type of dispute resolution. Both China and Thailand usually do not like to resolve disputes by harsh means. These include, among other things, judicial settlement, among other things. Since it's involved third-party binding solution, we do not like a third party to tell us to do how to resolve the conflict. There should be no black and white, right and wrong. This is in the context of ASEAN, I think, as well as China, we do not like it. In the ASEAN context, it is interesting to note that in ASEAN Charter, the ASEAN do not have resolution of conflict by judicial settlement. We have everything like consultation, negotiation, good office mediation, which involve two-party or third-party non-binding, as well as arbitration at most. We do not have court resolution, okay? And even that, we have the arbitration, which is a third party, but binding. But if the arbitration cannot resolve the dispute, then the dispute can be the so-called unresolved dispute, which has to be transferred to the ASEAN Summit for the solution. The ASEAN Summit do the function, something like conciliation, And I have read one article written by three scholars like Gu Xining, Edwina Kwan, and Josephine in their articles entitled The Lives of Chinese Investors as Claimants. What are the likely impacts on international arbitration? And I'm striking at one sentence. They say that rather, Chinese party value cordially and maintenance of friendly relations, even in the conduct of dispute resolution. And as such, Chinese parties demonstrate a level of geniality, which is generally uncommon in international commercial arbitration. In the majority of instances, this genial approach is misinterpreted by the other party, the arbitral tribunal, or the arbitral center, if any, as a sign of concession, or worse, an admission of the fault. If this statement is true, the mentality of the Chinese people is the same as Thailand and ASEAN member state, as aforementioned state, okay? And that is, if there is such a thing, the cooperation between the two countries will be highly likely. Okay, number 4, is there any trade and investment cooperation agreement between China on the one hand and Thailand together with the ASEAN member state on the other hand? We have a long list, which I will not delve into the details. What I would like to do here is just to mention the agreements which will contribute to the ADR cooperation between China and Thailand. The first one, the name is too long. I just would like to mention Thailand-China BIT. BIT stands for Bilateral Investment Treaty. The second one is Thailand-Hong Kong BIT, because I regard Hong Kong is a part of China. Thailand and Hong Kong BIT. And the third one is the Hong Kong ASEAN BIT, Bilateral Investment Treaties. And the last one is China ASEAN BIT. All of them have something in common. For example, in terms of expropriation of private property, including investment property. All of them have a common provision. For example, when you are going to invest in Thailand or in China, the whole state must accord fair and equitable treatment. Secondly, you have to accord full protection and security. And if a dispute arises, you have to settle by some means, including arbitration. And the most important thing is that there shall be no expropriation except for public purpose and against compensation. And the compensation must be the just compensation, which is the compensation must be paid in a prompt manner in the highest possible market value, something like that. And if the agreement cannot be resolved by means of negotiation, then you have to go to arbitration. The agreement has already laid down for a resolution of dispute by the ADR, and one of them is arbitration. And not only that, you can also use mediation or conciliation if you want to, and it can be conducted at the same time as you have already undertaken the arbitration. Okay, all I can say here is that it's not much because we don't have much time. And it is interesting to note that Thailand and China also do have something like what we call the agreement on investment of the framework agreement on comprehensive economic cooperation. Okay, the name is too long, but as I have already stated, I would like to make it short, like China ASEAN BIT. And this BIT have its own resolution of the dispute, which is very similar to the dispute resolution in the World Trade Organization, okay, which have some provision very interestingly, like Article 2, Paragraph 4. If there is a dispute which has been undertaken by the central, regional, or local government or authority within the territory of either party, then you can use this kind of dispute resolution to resolve. First of all, you have to use the diplomatic means by means of negotiation. But if the negotiation fails, you can set up the panel, which is very similar to the World Trade Organization. We have a time frame for the consultation as well as a time frame for the panel too. So this is another option. In addition to good office mediation and conciliation, now we have also panel, which I regard it is very similar to arbitration. Okay, so now the rule is in place. Okay, so I would like to further ask another question and to answer by myself that is there any ADR cooperation between Thailand and China? As the first speaker has already pointed out, the TCIAC, I will not go to detail about that. But I would like to mention that at the present time, we have several arbitration centers. The first one is the Thai Chamber of Commerce, which was established in 1968. And it is the oldest arbitration center in Thailand. And this center already have the agreement with arbitration center in China. The agreement is the agreement between the commerce and the commercial arbitration association of the Republic of China and the Board of Trade of Thailand. And the solution and the mechanism is very simple. You would like to the two arbitration center. The agreement will encourage the investor and the trader whenever they have a contract with each other, they just put the arbitration clause saying that all dispute may arise between the parties, which mean Thailand or China, out of or in relation to this contract shall be settled by arbitration under the Chinese-Thai arbitration agreement, which is this agreement. The place of arbitration shall be, unless otherwise agreed between the parties, the country in which the respondent reside, wherever the respondent reside, that place will be the place of arbitration. In case of the respondent is an enterprise of the Republic of China, then the place of arbitration shall be Republic of China. Or reversely, in case the respondent is an enterprise of Thailand, the arbitration shall be conducted by the Office of Arbitration Tribunal. Okay. The second one is the TAI, Thai Arbitration Center. It was established in 1991. It is now under the supervision of the Arbitration Office of the Judiciary, but it is independent from the Ministry of Justice. Okay. It has its own roster of qualified lawyers and legal scholars, and who have potential to be arbitrators in various fields of commercial dispute. It has its own rules of procedures. And of course, the THAC was established by its own law, and that is the Arbitration Institute Act of 2007. It has started its operation since 2015. Okay. And in addition to that, we have the tripartite agreement, which the first speaker has already elaborated on that. And then I will not delve into details. Okay. And what I would like to mention here is that not only that we have at least 4 arbitration centers, we have already relaxed the impediments in terms of visa or something like that. In terms of ADR, alternative dispute resolution, mediation, conciliation, and arbitration, Thailand has relaxed legal impediments to enable Thailand to be one of the favorable centers of international arbitration and mediation in the world. Thailand is now allowing foreign lawyers to represent their clients in arbitration and mediation proceeding. Maybe the FICC too. The first speaker has already pointed out. And in addition to that, Thailand is also implementing the so-called fast and smart visa, which means that foreign arbitrator or mediators can get into Thailand very easily at the moment. We also relax the work permit for foreign professionals. In addition to that, the cost of living and the fee for the ADR in Thailand is comparatively low comparing to other DR, as the first speaker has already mentioned. In addition, Thailand is situated in the heart of Southeast Asia, which makes it indispensable for the implementation of the AEC and BRI, which I have already mentioned. Since 2015, the ASEAN member state declared itself to be ASEAN Economic Community, and therefore it should have some trade and economic relations as well as investment relation with any countries in the world, especially China. And as I have already mentioned at the very beginning, that China has also have the Belt and Road Initiative. Both the AEC and the BRI will bring about or will contribute to more ADI cooperation between two countries. Insofar as AEC is concerned, I would like to mention one program of the ASEAN, and that is the Kunming Singapore High-Speed Railway. This railway starts from Kunming in the southern part of China and pass through Thailand, Malaysia, and then Singapore. And if that is the case, it is naturally conflict may arise as a matter of course. And if the conflict arises, of course, there must be a resolution. And which should be the best ADR resolution in this context? If we consider the cost involved, if we consider the relaxation which have already taken place, maybe the ADI cooperation between Thailand and China will be very prosper, will help to solve the solution. And I will speak this question lastly in order to save time for other speaker. And if you have any question, you can return to me. Will there be any impediment on ADR cooperation between Thailand and China? There may be some impediments. The impediment may stem from the China Belt and Road Initiative and the recent emergence of international commercial and investment courts in some major countries, such as Amsterdam, Frankfurt, Paris, Brussels, Dubai, Abu Dhabi, Singapore, and China. All of them vie for the options in the supplementary or even in place of the ADR. Okay. One of the rationales for the creation of the international commercial or investment court can be said to stem from the dissatisfaction with the judgments of several arbitration cases relating to investor-state dispute settlement, which we call ISDS. We have three types of arbitration. The first one is between private investor or private traders. The second one is between private investor and the host and the host state. And the third one is arbitration between state and state. The very interesting one is the ISDS, investor-state dispute resolution. At this time, the European Union has declared in one case that I think the case here is the ECJ, is the European Court of Justice, decided in the Slovakia and Acme on 6 March 2018 that the BIT between some of the European members which contain arbitration clause are inconsistent with the EU law because they would like to use the EU law rather than the law provided for in the arbitration clause. This is very interesting. Maybe from the dissatisfaction with some of the cases, which I will tell you later. And the second reason for the ECJ is that the agreements between EU and Canada and Vietnam, which provide for court as a means to settle the dispute rather than arbitration. The trend now is that we may shy away from arbitration and opt for the court. It's very interesting. The trend has just started less than 10 years. Okay, so I would like to mention one case. One case is that between I am not so sure if I read it right, Compañía de Sarroto, the Santa Elena, okay, and the Republic of Costa Rica. It decided that expropriatory environmental measures, no matter how laudable and beneficial to the society as a whole, are in this respect similar to any other expropriatory measure that state may take into order to implement its policy. Wherever property is expropriated, even more or even for environmental purpose, the state obligation remains. It has to pay compensation. The decision derived from the interpretation of the clause fair and equitable treatment very liberally. It say that if the host state pass law regulation requirements to such an effect to make a negative effect on the investment or may have disrupt the legitimate expectation of the investor that they want profits. But if you have undertaken some measure to protect the environment, and if such measures do disrupt the expectation of the investor, then the state has to pay compensation, notwithstanding the policy or the measure is for the benefit of the people. So I would like to stop here in order to allow time for other speakers. And if any participant would like to ask me, I am very happy to answer. Thank you very much for your understanding. Thank you. I would like to return the floor to the moderator. Yes.
I'm sorry, I can't hear.
Sorry, everyone, it's just a technical issue. Firstly, I want to thank Dr. Tenne for giving such an inspiring and clear structure of the ADRS between China and Thailand. Thank you. And for the audience who would like to ask more questions, we're going to answer together at the question and answer section later. Now, let me introduce our next speaker, Mr. Gasing. Mr. Gasing is in the field of domestic and international trade and also acts like a business legal advisor. He is a qualified arbitrator mediator of Singapore, Australia institution. He has worked closely with clients throughout the entire dispute resolution process. Now he's currently acting as mediator of Thailand Arbitration Center. So let's welcome Ms. Gassen to give the next speech, and his subject is the trend of dispute resolution and the advantages of ADRs in practice. Let's welcome him.
Thank you very much, Ms. Lee. And good afternoon, and everyone, ladies and gentlemen. And first of all, I would like to say that I'm not going to spend so much time on this seminar because I still have another speaker, Mr. Alex Fan, still behind me. Okay, so I will just, my topic today is the trends of dispute resolutions and the advantage of ADR in practice. So I'll just do it as a formal, okay, less formal, sorry. So far now in the world of the business, especially cross-border business or international trading, international trades, normally this comes with the highest capital, highest competitive, and also things are business, are models, everything are changed very fast. And also now that a lot of Chinese that are coming to invest in Thailand, you know, it's between Thai and Chinese. Before this COVID situations, there's a lot of Chinese. Every day's way, I mean, like in a shopping center, in the road, in the street, Pattaya, Bangkok, and everywhere in Thailand, you can see the Chinese people. That's including the tourists, including all the investors, and all the people who came to do business in Thailand. All this because of our language, you know, when you do a business, a cross-border business or international trade, of course, there is have to play a part with the language, culture, law, and rules. So that's why all these things may cause a conflict. And because of business nowadays is changing so fast, it's very high competitive and high capital. Of course, people, business people or investors are concerned of cost and times. So very important. So when there are conflicts that happens, so because of these things, because of like the language, culture, law, and rules as a difference, when they have investors comes or to do invest or to do business in the cross-border or international trade, all this may cause the conflict. Dispute will happen. So how we are going to deal or manage with the dispute? And normally in the olden days or even the present days, the business people who didn't know about the ADR, usually the first thing they will think is about litigations or ordinary judicial. That is normally when we have a conflict. The business people, most of the business people or most of the investors, that's the first thing they will think about this first, to go to the lawyer using a litigation or judicial or ordinary judicial. But nowadays, in this we call this new business era, ADR still is the best way to resolve the dispute in the way of the business. In the way of the benefit your business and the partner. So ADR, which includes arbitrations or mediations, is becoming increasingly popular with the international trade. For example, like a construction, intellectual property, and technology sectors. Because of the expediencies and substantial cost saving its efforts. So for my suggestion, as to find a way to take an advantage, the ADR is potential economics of cost and time because of less formal, but its facilitation. ADR process is, to me, it's cheaper and faster than ordinary judicial proceeding. For my perspective, could be thought of as up over, in some ways, a bird's eye view of the ADRs, but in particular mediation. Of other thing, this for me, when I'm in Bangkok now, I'm working closely with THAC as the mediator. So the THAC nowadays are in Thailand now, in the previous times, there are businessmen in Thailand that do not know about the ADR so much. But nowadays, THAC, they are giving educate to the business people, to the government sector, even to the lawyer and to the law firm. So nowadays, a lot of people in Thailand is getting knows about ADR as well. For the responsibilities of the mediations, I would like to talk about mediation more than arbitration because it's the first two speakers is talking about arbitrations already. So I would like to talk about mediations more. So I would like to talk about responsibilities of mediation. The mediation is to help you identify important issue and also to help you to clarify misunderstandings of your business and also help you to explore solutions, negotiation, settlement, which is does not, and the ADRs of especially mediation does not compel parties to settle, and also does not decide who should win in mediations, decisions makings, does not decide who should win. And also in mediation, the decisions making by the parties must be voluntary. So this is a good way of the people who do business. Because when you use our litigations, of course, lawyers, you must have lawyers to advocate you, right? And also the fee, a part of another reason is the fee. The fee of mediations include when you compare with litigations, I'm talking about ADR, even including arbitration as well. The fees of ADR usually is split equally by both parties, which is different from the litigation. And let me complain this way, using the mediations, okay? Mediation is more resolve the dispute. But if you're using a lawyer is an advocate, which you have to hire to help you advocate. And mediation is neutral, does not have any advocate. And also litigations is equally battle, because you have to hire the lawyers to help you to fight. So these things are not really, it's not really good for the business actually. Because when you're dealing with the business, of course, because of time consuming, cost consuming. If we're dealing with the business, for example, with the people who come to do the business in Thailand, or we have a cross-border business, of course, all those business people, they're throwing a lot of money. So they don't want to drag it a long time. And of course, when you bring the case to the court or the litigations, you must hire the lawyers to advocate you and fight to win. And what is end up, right? So when even that you win the case, but when you step down, the money that you are already invested so much in your business with your partner, with your business partner, that is your, you may not recall the business back again because of you fight, when you're in the court, you have to fight to win, right? So that I find that the ADR is the best way to solve the dispute. So that's why I'm really to recommend this all the investor or those cross-border business people to use the ADR, okay? And especially now that even that you think that in Thailand just language may have a little problem, but I would like to tell you is now a Chinese student if you go to the many university in Thailand, now a Chinese student has come to study in Thailand, which is of those people, they can use a bilingual language. They can speak Thai very well. Of course, the Chinese is their main language. And also nowadays, many Thai people also be able to speak Chinese as well, because we have a lot of Chinese tourists, more than 20 years, and we have a lot of Chinese who come to invest in business in Thailand. Even me, I do speak Mandarins, simple Mandarin, and do understand simple Mandarin as well. So in this case, I can help you if you are to use all the ADR. So my speech today is I do not want to spend so much time, and also this is one of my speech that to let you understand ADR, especially the mediations. Thank you. For the questions, so I think that it could be at the ends of all the speaker, right? After all the speaker talk. So I would like to return this floor to Ms. Lee, the moderator. Thank you.
Thank you, Mr. Gassing. Thank you. It is very clear from your introduction about the advantages that ADR has bring to us compared to the traditional dispute resolution method. Thank you. So
Thank you.
Let's run to our last speaker. I would like to introduce you, Mr. Alex Fan. Mr. Fan, he is the president of Hainan International Arbitration Court. Today is very honored to have him to speak for us, and he is also the barrister of Hong Kong, a senior member of Chartered Institute of Arbitration of United Kingdom, accredited mediator recognized in Hong Kong. He has worked in the Criminal Prosecution Division and Civil Litigation Unit of Hong Kong as well. Mr. Fan has extensive experience in commercial dispute resolution, corporate governance, real estate trusting, and international commercial arbitration. Thank you. So let's welcome Mr. Fan give us a speech on the managing cross-border for Chinese disputes through ADRS. Thank you.
Thank you, Chan. Nice to meet all of you, distinguished guests, our friends from Thailand and China. Nice to meet all of you. It's very honored for me to give my speech here on behalf of HIAC. And this is the first time that I speak in public for the in arbitration court since my appointment a few months ago. Having regard to what our fellow speakers have said on the topic, my content of sharing will be focusing on the enforcement side of the ADR mechanism. Before we go to the substance of what I'm going to speak about, let me say a few words to introduce our HIAC. I believe our chairman, Mr. Wang, has already given you a brief introduction about Hainan International Arbitration Court. I try my best not to repeat Mr. Chairman said, but I want to supplement to you some further information about our arbitration court. As we know, our HIAC is one of the top 10 arbitration institutions in China, and we have a rebranding exercise very recently this year as a reform of our former Hainan Arbitration Commission. And indeed, we are the first arbitration institution in China operated as a statutory body at the provincial level. And we are governed by a board of directors. We're quite different from other arbitration commission in mainland China. And our establishment is to serve the very purpose to assist the development of international arbitration service alongside the development of the Hainan Free Trade Port, which is to be fully in place by 2025, a few years later. And our board members come from over the world, and we have a very diverse background of arbitrators. Well, we have more than 900 arbitrators, and among the 900 arbitrators, we have more than 200 from with the foreign nationalities from over more than 40 countries. In terms of case loads and case volumes, last year we have more than 2,700 cases, and with a total subject matter involving more than 6.5 billion RMB. We also recently set up our International Commercial Mediation Center very recently, a few months ago. And at the moment, we have more than 300 mediators, and among which 80 of them are with foreign nationalities. And we also actively develop our ODR, the Online Dispute Resolution Facilities, with specific regard to the resolution of financial disputes using ODR as a means. So why do I choose the topic of enforcement today to share with all of you? Indeed, as all we know from our fellow panel speakers, they have already given us a very good sharing about what ADR choices do we have and how should we make those choices, and some recent development in China, in Thailand, and in the Thai-Chinese cooperation. But when we come to enforcement, it is of course important. Once we solve dispute by litigation or by ADR, for example, mediation or arbitration, right? The parties have to bring the outcome into practice, and that is enforcement, to manifest their legal rights or entitlement after they have gone through all the ADR processes. And enforcement is important. As we all know, we have all sorts of international commercial transactions, and parties from different countries, country A, country B, and they may have some transaction in country C. And of course, when we talk about enforcement, you have to chase after the assets of the parties against whom we are going to enforce the arbitral awards or the judgment. And of course, we also have to chase after the place where the party ordinarily resides, or we have the concept of domicile, right? Where the party's domicile. So enforcement, I believe, is a very important topic after we have gone through all the earlier parts of the ADR process, and we have come to the last and the most important part of the ADR process. I will further narrow down my topic of sharing to enforcement of arbitral awards in China. I'll give you an overview so that I hope after my speech, and then all of you may have some basic understanding about what's going to happen if we want to enforce a foreign arbitral award in China. To start with, as you can see on the screen, these are the statutory or the legal framework of enforcing an arbitral award in China. As with many other countries in the world, we are also a party to the New York Convention. I believe all of you are very familiar with the New York Convention. I don't think I have to spend a lot of time to explain to you the contents, but of course I will focus on some highlights of the New York Convention, especially Article 4 and 5. And after our country, China, become a contracting state of the New York Conventions, and we ratified in 1986, and it took effect in China since 1987. And we have passed some local legislation or decision by the NPCSC decision, that is the decision of our national legislature, the National People's Congress. And our Supreme Court, the SPC in short, also noticed on the New York Convention, which we will look at it closely in a moment. And of course, later we have the Chinese-Thai Treaty about the judicial assistance in civil and commercial matters, and we will focus on the parts related to arbitration. And in fact, for information, China signed 39 bilateral treaties, and 36 of them contains provision about the enforcement of arbitral awards. And then we come to the domestic law, the civil procedural law, which is about the enforcement mechanism. And this civil procedural law, CPL, is also supplemented by a subsequent interpretation of our Supreme People's Court. So we start with the CPL, and the starting point we have the framework, and just it seems it just simply says that if an award made by a foreign arbitration institution, and it has to be recognized and executed, and how can we do it? And the party can directly apply to the Intermediate People's Court, the place where the party's domicile or where his property is located. And most important thing is the provision make reference to the international treaties concluded or acceded to by China, or in accordance with the principle of reciprocity. So it refers to international treaties. So of course, then in the context of today's discussion, of course, we will focus on the Chinese and Thailand's cooperation, right? And then we have the Chinese-Thai Treaty, and the relevant articles can be found in articles 19 and 20. And 19 is a more general provision about fostering the cooperation between the two countries, and the two countries agree to promote arbitration, encourage arbitration organizations like what we have is the TCIAC and other institutions, and exchange of lists of arbitrators, facilities, and grant convenience, and things like that. And most importantly, and Article 20, it also once again affirmed the applicability of the New York Convention to recognize and enforce the arbitral awards between the two countries. One thing I would like to draw our audience attention to is, in fact, when China ratified the New York Convention, in fact, China has made reservation to the application of treaties, and we can find in the NPCSA decision, and it said that China will apply the convention only to the differences arising out of legal relationships, whether contractual or not, which are considered commercial, right, under the national law of China. And then we can move on to have a look on the SPC notice, which further explain what it means commercial, right? It means that everything outside the scope of commercial as defined in Chinese domestic law, it cannot be a subject matter of recognition and enforcement, right? That's the restriction, right? And yeah, I have tried to list out all the definition here, which you can take a look. I don't seek to recite and repeat everything, and mainly prescribe the context of commercial law, which is capable of being the subject matter to be enforced or recognized, right? Okay, and it also mentions some procedural aspect of the enforcement. And we can also take a look on paragraph 4 of the SPC notice. And it again reiterate what is said in the New York Convention, Article 5, and we will go to that in seconds, which deals with the ground on which the domestic court can refuse the recognition and enforcement of the arbitral awards granted by an overseas arbitration institutions. Right. Okay. Very quick recapitulation of what is said about the enforcement and recognition under the New York Convention. Right. And Article 4 is important. It refers to some procedural aspects of or requisite conditions for enforcement, right? If you want to recognize and enforce an arbitral award, of course, you have to, the party who wants to recognize or enforce the award need to supply the duly authenticated original award or duly certified copy, as well as the original agreement. Agreement here, we refer to the arbitration agreement, right? The written agreement which lead the party to agree on the process of arbitration, right? And also, here paragraph 2 also impose another condition is about the translation of document and the language of the country in which the award is to be enforced, right? And Article 5 is about the grounds on which the court, for example, if we talk about enforcement in China, is about the grounds on which Chinese courts can refuse enforcement and recognition, right? To name a few examples about the invalidity of the agreement, arbitration agreements, some impropriety during the appointment of arbitrator, or during the arbitration proceedings process, beyond the scope of the agreed arbitration arrangement, and the issue about the composition of the arbitral authority, and the award has not yet become legally binding on the parties, and that's about the finality of the award, right? And also subject to the rules, the domestic law of the country where the enforcement is sought. For example, if you want to enforce an award in China, of course, the enforcement and recognition is definitely subject to the law in China, the relevant law in China. Of course, the final part is about the any award or the recognition and enforcement of it would be contrary to the public policy of the country. Okay. So next thing is about the SPC interpretation concerning the CPL, right? As I said, the civil procedural law is the main skeleton for us to deal with various aspects of civil litigation, and including the aspects concerning enforcement and recognition of foreign judgments and arbitration award. And the Supreme People's Court interpretation is to give us some supplemental guidelines to the CPL, right? So, and this, once again, it spells out the requirement of the legally binding nature of the foreign arbitration award, right? And you have to apply to the competent People's Court for recognition, and also refer to the Part 3 of the Civil Procedural Law. And in fact, Part 3 of the Civil Procedural Law deals with the ordinary procedure of enforcement and recognition for local judgment. He says that the ordinary rules shall also apply to the recognition and enforcement of an arbitral awards. And one thing you may want to specifically note is that, in fact, we are in CPL, or in this interpretation, we try to distinguish the recognition from enforcement, right? That is how we treat the process, and I understand some countries they have little distinction between recognition and enforcement, but we make such an distinction as a matter of law, and you have an option to do both procedures together, or just to do with the recognition first and followed by enforcement. And the time limit, it refers to the CPL, which says the 2 years, and about counting of the 2 years limitation period, of course, from the last day of the time limit for satisfaction of the judgment specified in the arbitral award. Of if it does not provide a time limit expressly, then we will count the 2 years time from the effective date of the legal documentation, which is the arbitral award. And we have also specific provision to recognize the enforceability of ad hoc arbitration, right? As for those who are familiar with the arbitration arena in China, ad hoc arbitration is still developing in our country, and in fact, China is still very much dependent on institutional arbitration, right? And of course, with this Article 545 of the interpretation of SPC, although we are still experimenting with the in the early stage of the ad hoc arbitration in our country, we still give express recognition to the enforceability of ad hoc arbitration granted by an arbitration tribunal outside China. Right? This is very important. Okay, as Chang, our moderator, also when she introduced my background, I come from Hong Kong, so I would also take this opportunity to share with you about the enforcement of arbitral awards in Hong Kong very briefly. Right. In fact, Hong Kong is a separate jurisdiction in China. Right, we're also part of China, and the special thing about us is we are the only common law jurisdiction, right, under China, and operating in accordance with the principles of one country, two systems. It's authorized by our constitution and the basic law, which is the law with a constitutional nature within Hong Kong, right? And another special feature about us is we have dual official languages, Chinese and English. And indeed, in the context of civil litigation, and most importantly, commercial arbitration, right, international and domestic, English remains the key language of practice, right? And we have a lot of foreign practitioners as arbitrators and as counsel in our arbitration and civil court proceedings, right? And we have the leading arbitration center, Hong Kong IHC, right? So when we come to the legal framework in Hong Kong, of course, New York Convention is equally applicable in Hong Kong. And recent years, we have a full review and reform of our arbitration law. We have the arbitration ordinance. It's first attempt to fully receive the UNCITRAL model law. So we are model law jurisdiction, right? And we have our civil procedural rules to enforce the award, right? In fact, we have two main ways to enforce and foreign award in Hong Kong. The first way is to start a fresh legal action based on the award itself, right? It's a traditional way. And the second is what we call the fast track summary procedure. It's quite special. We have a fast track procedure to go through some brief registration procedure under our new ordinance. Then we can hopefully successfully enforce the award against the property or the subject domicile in Hong Kong. Right? And we can also skip the part of recognition and directly use the awards granted by a foreign court or arbitration institution to use it as a basis for liability, as a debt, to start the winding up or bankruptcy proceedings against the liable companies or individuals, right? And we have also a comprehensive set of procedures to provide injunction and freezing orders in aid of the foreign arbitration proceedings, right? So apart from China, the mainland China, Hainan, and if we have some property asset in Hong Kong, the subject came to Hong Kong, you can also consider enforcement of the awards in Hong Kong, right? So that's nearly all what I want to say about today. So maybe I pass the floor back to the moderator. Thank you very much.
Thank you very much, Mr. Fan. Thank you for your sharing. It is very meaningful for us, and we now have a better understanding for the enforcement of the arbitral award, maybe in China, Thailand, in Hong Kong as well. Thank you. So right now, I would like to press my many thanks to all the speakers for your insightful presentation today. Your speeches are very informative and inspiring. I believe they will help us and our audience to have a better understanding of the development of cross-border dispute resolution through ADRS. So thank you, Mr. Shidato. Thank you, Mr. Tennis. Thank you, Mr. Gassing, and thank you, Mr. Axpan. Thank you for your sharing. And may I express my special thanks to Mr. Li Feng, initial representative of China Council for the Promotion of International Trade, CCPIT. He is here at the presence of webinar today, which means to us a lot and give us a lot of support. Thank him a lot. Thank you. So let's move to the question and answer portion of this section final. So please, every audience, please feel free to ask any questions to our speakers. In fairness to our speakers and other attendants, only one question per person per time. Thank you. So I have received some questions on the screen for the previous time. Let's start from them first. So we have one question. Please be so kind to explain the difference and the coordination between TCIAC and THAC. As the General Secretary of TCIAC, Mr. Shidato, could you please answer this question, please? Please come here. Yeah. Please be kind to explain the difference and coordination between TCIAC and THAC.
Okay, very good question. Actually, as we mentioned before, TCIAC was founded by THAC and Hainan International Arbitration Court. And so THAC is one of the founders, and the TCIAC specializes in cross-border dispute resolution in relation to China. So and also TCIAC is under our office was in THAC, and as you know, in Thailand, every arbitration institution have their constitution law. So TCIAC is under THAC the law. To TCIAC under THAC constitution law in order to have the independent arbitration. I think, yeah, this is my answer. Thank you.
Thank you, Mr. Shidato, for your answer. Thank you. It's very clear. Yeah. So let's move to the next question. We have another question for Dr. Thanet. Dr. Thanet, you mentioned Thailand relaxation of legal impediments for foreign lawyers to represent their clients in arbitration and the mediation proceedings. That mean that the foreign lawyers can argue on matters concerning Thai law. Additionally, and out of the curiosity, how is the status of the things in China? Are foreign lawyers allowed to represent clients before arbitral tribunals or in China? Dr. Thanet, can you answer this question for our audience, please? Thank you. Hello, doctor, you are muted. Could you open the speaker, please?
I put it on, okay. As I have already stated at the very beginning that at the present time, TCIAC has relaxed some impediments somewhat in order to enable Thailand to be one of the centers, the famous center for dispute resolution in the world. As I have already stated, Thailand is now allowing foreign lawyers to represent their clients in arbitration and mediation proceeding in the countries. If my information is correct, Thailand is also implementing the so-called fast and smart visa. If you relax the rules on ADR, but if you do not relax other pertinent laws, for example, visa, then foreign lawyers cannot come into Thailand. So we recognize that, and we therefore amend somewhat the law on the visa, which we call fast and smart visa. So it means that foreign arbitrators as well as foreign lawyers may apply and get a visa more easily than before. And in addition to that, the visa may not be enough because once the foreign lawyers and arbitrators come to work in Thailand, it is within the another law. It's like working permit law. I understand that Thailand is now also relaxed the work permit in order to allow the foreign professionals to do the work in Thailand. And especially what we think to be our major strong point is the cost of living in Thailand is very, very low. And the fee for ADR in Thailand is comparatively low comparing to ADR in other countries, including Singapore. I think I understand that the first speaker has already mentioned about this. This is my answer. Is that enough? Hello. Thank you very much for the answer for the question. Thank you.
Thank you, Doctor. It's very clear for me. And
may I say something regarding the second part of the question? And the question specifically mentions are foreign lawyers allowed to represent clients before arbitral tribunals in China? And this question is quite complicated. Generally speaking, the restriction about practicing as a lawyer still apply to foreigners. It means that, for example, a foreign lawyer cannot participate in Chinese arbitral proceedings as a lawyer in arbitral proceedings, but he can participate in the proceedings as an agent of his client. And then some further restrictions is about what he can do in the arbitral proceedings, and the laws cannot in the arbitral proceedings as an agent to say representation as to Chinese law's applicability or anything about Chinese law, right? It's not a straightforward yes and no question, but honestly, in some specific, for example, in our TP, in the Hainan FTP, we will soon be doing something to try to put forward a trend or a way to relax this restriction to encourage those international commercial arbitration activities to take place in some specific zone in China. So stay tuned with us, stay tuned with Hainan, right? And of course, you can come to Hong Kong, right? Thank you.
Thank you. Thank you, Mr. Axelfan. Thank you for your answer. And is there any audience who want to raise up more questions? Our speakers are willing to answer your question. Okay, so if there's no more questions, I think that is pretty much for our seminar today. And ladies and gentlemen, I want to thank you very much for your attending here today for this seminar. And it means a lot to TCIAC because this is just a newly founded arbitration center especially between Thailand and China. And I believe by our effort, we are gonna be able to fund it and with keep cooperation between Thailand and China to rebuild our relationship and to solve the dispute between the investors and tradings to make everything better. So I hope you enjoyed this webinar, and hopefully this webinar will be beneficial for every one of us. Thank you for your attendance. Good afternoon. Thank you.
Thank you. Bye. Thank you.
Thank you, everybody. See you.